Okay, good morning, everyone. I am hoping very much that I can have my issues with my system fixed by next meeting, but for today, I'm going to stay off screen. I am dressed, I am not in my pajamas, so it isn't like I'm not prepared. Okay, first of all, I want to say good morning, everyone. I want to wish all of the moms who are with us today a one-day belated Happy Mother's Day. I hope you are all with those wonderful creatures who made you a mom and that you had a great day with your children. First, I want to say that next month on June 13th, our guests will be the Attorney General candidates, Congressman Anthony Brown and Katie Curran O'Malley. And I want to now thank our 6 guests today. We are joined by the 4 sitting judges and the 2 challengers. And I do hope that you've had an opportunity to read the document that I sent you regarding Maryland's judicial selection process. The guests are reminded of this. Well, first I'll just go down to let you know who our guests are. They are Judge Carlos Acosta, Judge Teresa Chernovsky, Judge Kathleen Dumais, Mr. Thomas Johnson, Judge Rachel McGuckian, and Ms. Marilyn Pierre. They will have a 5-minute opening statement that includes their bio. Closing statements will be 2 minutes, 2-minute responses to questions and no rebuttals. I'm going to reserve the right to ask follow-up questions. There may be a question directed at individuals rather than the whole group. Starting with Judge Acosta, we will begin with opening statements.
Thank you, Susan. Good morning. Good morning to the folks here today. I want to thank the District 18 Democratic Club for inviting us. Judge Carlos Acosta of the Montgomery County Circuit Court. It's an honor and privilege to be invited to meet with you all today. I'd like to introduce myself. I was born here in Washington, D.C., and I grew up in the Maryland suburbs. I graduated from St. Bernadette's in Silver Spring, Maryland, then Good Counsel High School, which was then in Wheaton, Maryland. I went to the University of Maryland, for which I attained a BA in English and later a master's, also in English and rhetoric. I went to SMU in Dallas, Texas for my Juris Doctorate. I then came back to Maryland and I clerked for the Honorable Vincent E. Ferretti Jr. I worked for the big firms, at that time about 800 lawyers, and my group did aviation disaster litigation. I came back to Montgomery County to work in the state's attorney's office as an assistant state's attorney. During my tenure there, I was on the following teams. So on the district court, the juvenile court team, the general felony trial team, the family violence unit, and the white collar crime unit. I then left to join a friend in his practice, which was 2 lawyers, 6 staff members, and then the attorneys practiced criminal defense, personal injury, and workers' comp. A little bit after that, I moved to a bit bigger firm, 8 lawyers, and I did mostly criminal defense. Afterwards, I was asked to join the Prince George's County State's Attorney's Office to be in their violent crime unit, which they just constituted. That unit was responsible for handling serial criminals, major recidivists, gang cases, and homicides. This is where I learned how to be a gang prosecutor. During my time at the Prince George's County State's Attorney's Office, pardon me, I was loaned out to the U.S. Attorney's Office in the District of Columbia as a special assistant U.S. attorney. I was assigned to the narcotics and organized crime section. When I returned to Prince George's County State's Attorney's Office, I was made the violent crime unit section head. I then went back to the DOJ and I became a founding member of a unit they called the Gang Squad. I coordinated DOJ's efforts regarding the California Mexican Mafia. I also had my hand in MS-13 investigations, as well as an outlaws motorcycle gang double homicide. I returned again to Prince George's County, then as the deputy state's attorney. So I was the number 2 in the office. In that role, I was the trial deputy and responsible for the homicide unit, the violent crime unit, general felony trial, and the grand jury units. Towards the end of the elected second term in office, I was fortunate enough to go back to DOJ, to the Overseas Prosecution Development and Training Section, OPDAT. I was assigned to be the program manager for the U.S.-Mexican Initiative to reform Mexico's entire criminal justice system. They were beginning to, and I will say still are, in transition from an inquisitorial civil rule of law system, which was left by France in 1867. A very modern system then, but Mexico determined that they were in need of a replacement now. That was a great experience. Thereafter, I was approached by the Prince George's County Police Department to join them to reinstitute their Office of the Inspector General. I did so, and I told them I stayed for 2 years. I stayed 6. I was then appointed by the governor to the district court, and I sat on the bench across the street from where I am now, hearing cases for 4 years. Early January of this year, I was sworn into the circuit court. As I give you this background on myself, please know that while the particulars of their careers differ in subject matter and physical locations, the other 3 sitting judges have the same depth and breadth of career achievements and experience as I do. Each one of us was selected from an intensely vetted group of experienced lawyers who made the grade and accordingly made the short list sent to the governor. Thank you, Susan.
Morning, everyone. My name is Teresa Chernosky. I, as well, am a sitting judge on the Montgomery County Circuit Court. I want to take this time to thank you all for being here this morning, bright and early at 7:30. And thank you for listening to us and hearing some information about us so that when you go to the polls, you can make a choice that you feel is informed and the right decision for what you think is appropriate for our county. I was born and raised in Massachusetts. I went to school outside of Chicago at Lake Forest College for undergrad. I then got my Juris Doctorate from Albany Law School in Albany, New York. After that, I was married, and me and my husband moved to Kentucky, where I began my lifetime career as a public defender. In that initial system, my experience was throughout the entire criminal justice system. So I handled everything in district court and circuit court. So had trials anywhere from DUI up to rape, murder, and death penalty cases, as they still had the death penalty in Kentucky, where I practiced there. We had our first 2 children in Kentucky and decided that it was time to move somewhere with a better schooling system. And we picked Montgomery County, Maryland, moved here to raise our family. We've been here now for over 21 years, and I have continued my career as a public defender. In my work here in Montgomery County, I was a felony trial lawyer. I came in on the felony trial level, which means that I was trying the most serious cases. Again, that would be robberies, carjackings, homicides, rapes, child abuse, physical or sexual. The kind of joke in the office was I had the black mark on my door, meaning that I got some of the worst cases that came through our office and would try them or negotiate ways out of those in the best case scenario for my client, helping them to make informed choices. The reason that I went into public defense was my desire to articulate and to advocate for those who have very little voice and those who find themselves in the criminal justice system in probably the worst times in their lives. And I learned so much, not only about the law and about the criminal justice system, but about people and about compassion and patience, and who people are and how they get to the situations that they find themselves in. I learned what's important not only to them, but to the victims and their families. And I learned about the ripple effect and how what happens to one person affects not only their family, but also the families of the people who were victims in the case, and affects the community in terms of people's feeling safe or not safe in their community. So the information that I learned is what I'm bringing forward to the Montgomery County bench as a judge here. I learned not just the rules of evidence and how to try a case and how to be patient and direct and to communicate effectively, but to learn the people skills so that I can understand and listen to those who come before me and bring to me their problems and the issues that they have been having a difficult time determining an appropriate way out. So I've brought problem solving skills. I've brought listening to learn skills. I've brought compassion and empathy to the bench. And I've been appointed since December, and I'm on the family rotation. So I'm hearing cases such as divorce, custody, modifications, child support, domestic violence. So very important things in people's lives and in people's families in terms of affecting themselves and their children. A little bit about the vetting process that I want to make sure people understand is that when we are interviewing to get to the governor's shortlist, we meet with as many specialty bars that want to meet with us. And the list includes the J. Franklin Bourne Bar Association, the Maryland Defense Council, the Maryland Hispanic Bar Association, the LGBT Bar Association of Maryland, the Maryland State Bar, the Montgomery County State Bar, the Monumental City Bar Association, the Women's
30
Bar
seconds.
Association. Thank you. The Asian Pacific American Bar Association, the Alliance of Black Women Attorneys, the Maryland Association for Justice, the Women's Law Center, the Maryland Criminal Defense Attorneys Association, the Simon Soboloff Association, and any other associations that meet with us in order for the community or a representative of the community to understand who we are. Thank you so much for your time.
Judge Dumais.
Thank you. Good morning, everyone. I'm Judge Kathleen Dumais, and I was sworn in as an associate judge on the Circuit Court on December 2nd of 2021. And I'm running in this election to be retained as a judge for the Montgomery County Circuit Court, along with my colleagues who you're going to meet this morning, and two of whom you've already met. So this appointment and this job are a great honor and did require a great deal of vetting, as Judge Tarnowski just talked about. So I wanted to tell you a little bit about my background. I've lived in Montgomery County since 1989 and when I began practicing law. I grew up in Laurel, Maryland, and I've actually lived in Maryland my entire life, except for the first 6 weeks after I was born. I was actually born in La Jolla, California, because my father was in the Marine Corps at the time and stationed at Camp Pendleton. His tour of duty actually concluded when I was about 6 weeks old. And we moved to Maryland because my father started teaching in MCPS system. He had a 30-year career with MCPS, and he retired in 1988 as the principal of Seneca Valley High School. Many members of my family live in Montgomery County. I am the oldest of 8 children. I have 22 nieces and nephews. I have 4 great nieces and 4 great nephews. I'm fortunate that 7 of my siblings still live in the Washington metropolitan area. 3 of them live in Montgomery County. 1 is a Montgomery County police officer. My younger sister is a guidance counselor in the MCPS school system, following in my father's footsteps. My youngest brother actually doesn't live in Maryland. He lives in North Carolina, where he had a 20-year career in the U.S. Marines. He served 2 tours in Iraq and 2 in Afghanistan. I've always been very active in the community. For the past 19 years, I was an elected member of the Maryland House of Delegates, representing District 15, which runs from Potomac to the Frederick County line, west of 270. I served in leadership positions there. I was the majority leader. I was also the vice chair of the House Judiciary and House Economic Matters Committees. I served as a legislative representative on the Montgomery County Criminal Justice Coordinating Council for 19 years as well. Why did I go into law? I know it sounds kind of corny, but I was drawn to a legal career because I wanted to be able to help people through a difficult time in their lives in whatever capacity. My father always encouraged us to change our corner of the world, and that's what I wanted to do. So I've practiced law for 32 years before being sworn in as a member of the bench. Most of my cases were here in Montgomery County, but I also practiced in Prince George's, Frederick, Howard, and Baltimore counties. My practice was primarily in the area of family law, the divorce, custody, and domestic violence. I'm also trained as a mediator and did a great deal of mediation in my practice. My cases involved very complex property issues, contested custody issues. My litigation experience, I enjoyed litigating cases and certainly did my fair share. A few months went by that I was not in court 6 or 7 times. However, it often made the most sense, particularly I think in family cases, to resolve cases through mediation and negotiation. Litigation is expensive, and finding a resolution for a family of their difficult times, I think is more beneficial financially as well as emotionally for the family to do it through mediation. What do I want voters to know about me and my qualifications? I want people to understand that I believe in the importance of hearing both sides of any issue or any case, that I'm a good patient listener, that I'm committed to finding resolutions that are fair and just under the law. And what I believe is important for judges, the qualities: honesty, compassion, patience, sound legal knowledge, and a strong work ethic. And I believe I have those. I want to make a couple of points to follow up on what Judge Tarnowski said regarding the vetting system. Number one, the individuals that are appointed to the bench by the governor have been thoroughly vetted by at least 14 times by diverse bar associations and other groups described by Judge Chanowski before they even get to the trial court nominating commission. Once they get to the trial court nominating commission, that commission then does its own vetting. And then they prepare a list that goes to the governor. A large number of people are involved in this process. It's not one or two people. It is a vast number.
30 seconds.
Okay. The information provided by each candidate is incredibly comprehensive on both personal and professional levels, as it should be. And it's an amount of information that's not always readily available to voters. The merit selection process starts with the completion of a lengthy application. The application includes all of the information about cases that we have handled, our personal background, where we lived. I actually had to look up where I lived about 30 years ago, and had to go back to a DC bar application that long ago to find it. So
That's time, Judge. Thank you.
Okay.
Mr. Johnson.
And we look forward to more questions. Thank you.
Mr. Johnson, you're next.
Unmute yourself, sir.
How is it? Okay.
That's good.
Okay. I'm sorry. Good morning again. I'm Thomas P. Johnson III, candidate for Montgomery County Circuit Court Judge. Thank you for taking this time this morning to attend this event, and thank you, the Breakfast Club, for inviting me to speak. There are two things I want you to remember. Your vote counts, and choosing who sits on the court matters. My opposition's entire platform rests on their incumbency. Their website name includes the words elect sitting judges. Right in their website address. This cleverly hides their attitudes toward the electoral process. They feel this election is a formality, and they already have the seat on the bench, and that they just need you to check a box to finalize the process. If one thing is clear from the recent headlines about the judicial branch of our government, their verdicts are anything but formalities. As a judge and lawyers, we handle people's lives and livelihoods in the courtrooms. And we would approach the election process with exactly as much respect for the voter as we have for the rule of law. There has not been a Black male serving as a judge in Montgomery County in 6 years. Meanwhile, 70% of incarcerated persons in Maryland are African Americans. The vast majority of them are men. I am the only candidate with their life experience. In Montgomery County, 15% of the people identify as Black, while nearly 90% of the students that are detained by school safety officers are Black males. I was raised by my grandparents in New Orleans, Louisiana. I was born after Brown v. Board of Education and lived in the South when the Civil Rights Act became law. I watched the judicial system morph from explicit racism to more covert tactics. I realized that the only way to know the rule of law was being followed was to learn the law. I received my JD from Southern University Law Center in Baton Rouge, Louisiana, a historic Black law college. And I've practiced law for 29 years. It was not easy. I worked as a shipbuilder, a car salesman, a legal aid clerk, and a high school teacher to earn money. Then I dedicated my career to representing those who most often lack representation: laborers, veterans, and people with disabilities. I often provide work pro bono or at a reduced cost based on my clients' needs. I will bring the same reverence for equity and justice to my courtroom. I'm eager to answer your questions, and thank you for your time.
Judge McGuckian.
Good morning, and thank you very much for the opportunity to speak with everyone here, and thank you to the Breakfast Club. My name is Judge Rachel McGuckian. I was born in Silver Spring and raised in Rockville, where I still live. I attended all local schools, West Rockville, which is now Bell, Julius West, and Richard Montgomery. I'm a single mother who has raised my 2 daughters on my own, who are now in college. I come from a family that heavily values public service. My sister is a special education teacher and is taught in both Montgomery County and Prince George's County. My father, Paul McGuckian, who passed away last year, dedicated his life to public service and worked in the county for a long time for doing things for Charlie Gilchrist and Sid Kramer, among others. My mother, Eileen McGuckian, is a longtime historic preservationist. She's written books on the history of Rockville and on Montgomery County. She was a founder and the longtime executive director of Peerless Rockville and is currently heavily involved in preserving old cemeteries in Montgomery County. I attended the Johns Hopkins University and after that, the University of Baltimore School of Law, where I worked my way through law school and graduated close to the top of my class. I clerked for a federal judge, the Honorable Deborah K. Chazanow, and after that embarked on a 29-year career of private practice. During that time, I served on the Maryland State Board of Elections. I served on the State Ethics Commission. In terms of my private practice, the last 25 years of my practice were at Miles and Stockbridge, which is the largest Maryland headquartered law firm. I was very successful at my firm. I was an equity partner. I served 2 terms on the board of directors, and I was the managing partner of the Rockville office. I handled primarily civil and family law cases, but I also represented indigent defendants pro bono through the Office of the Public Defender. I've tried about every kind of case that you can try. And in fact, I was sworn in January 14th, having been appointed in November because I had trials I had to finish, including a 1-week trial in the Eastern District of Virginia the week before I was sworn in. I'm a fellow of the American College of Trial Lawyers, which is something you can only be invited to. Judge Chernosky is also a member of, a fellow of the American College, and it's the top 1% of trial lawyers in the country. I'm very proud to have served the National Guard as an officer in the JAG unit of the Maryland Defense Force. I retired in 2016 after more than a decade of service as a lieutenant colonel. I had a very eclectic client base over the years. I represented regular folks in personal injury cases. I represented professional sports teams and owners, car dealers, authors, small business owners, dentists, doctors, lawyers. I represented the town of Kensington for 5 years when Lynn Rofast was mayor. And I've represented, again, indigent defendants in criminal cases. I spent a lot of time speaking on issues of ethics. I've spoken around the world at places as diverse as South Korea, Argentina, Dubai, Dublin, Austria, all over the place to bring American ethics principles to the international bar. I have a depth and breadth of experience that I think is helpful to be a good judge, especially with the wide variety of cases that come before us on the circuit court. And I also have the patience and the temperament required to do the job well. I want to talk for a moment about the diversity of our bench. Our court truly reflects the diversity of our community. With the appointment of Judge Chernosky, Judge Dumais, and me, Judge McGuckian, we have for the first time a majority female bench in the circuit court. I sit on an all-female floor. With the appointment of Judge Acosta, we have the first Hispanic male judge on the circuit court for Montgomery County. Approximately 18% of Montgomery County residents are African American, and approximately 18% of the circuit court judges are African American. 25% of the district court judges are African American, and there are Hispanic and Asian judges on that court as well. In addition, on the circuit court, we have
30 seconds.
Openly LGBTQ judge sitting, as well as the first Asian judge. And just this year, from Montgomery County was appointed the first Asian judge on the Court of Special Appeals in Rosalind Tang, my former partner. At the same time, a Black openly gay male was appointed the chief judge of the Court of Special Appeals. So our slate is endorsed by a broad, diverse group as well. Will Smith, the chair of the Senate Judicial Proceedings Committee, endorses us. All of the Montgomery County senators, all of the living governors, the comptroller,
That's time, Judge. Thank you.
Thank you so much.
Ms. Pierre?
Yes, good morning, everyone. Good morning, District 18 Democratic Breakfast Club. I really miss seeing you guys at the Tasty Diner, and I hope that I get a chance to see you soon. I am Marilyn Pierre, and I am a candidate for Montgomery County Circuit Court Judge. I'm a graduate of Howard University School of Law, and I've been practicing law for over 30 years. Over 60% of the cases in the circuit court are family law cases. Because of my family law experience, I was appointed by the Montgomery County Circuit Court as a family law facilitator. As a family law facilitator, I helped the court resolve some of their issues, some of the cases in front of them where there were issues of child support, custody, visitation, and things of that sort. I served in that position successfully for nearly 30 years. I am also a United States Army veteran. I was an officer in the Military Police Corps. I am a Leadership in Law Award winner, a bar leader with the Montgomery County Bar Foundation, a former president of the J. Franklin Bourne Bar Association, which is Maryland's largest and most active specialty bar association. I am also a 3-time winner of Maryland's Top 100 Women and an MCDCC, for those of you who don't know that, sorry, it's the Montgomery County Democratic Central Committee Morgan Journey Community Service Award winner. There is a lot of talk about vetting in this, well, by the other candidates, and vetting makes sense. It does make sense to look at people and vet them, but it depends on who's doing the vetting. You know, yes, the bar associations have some things to say, but the bar associations definitely is not the final arbiter. The final arbiter is the governor's commission. And even though I have all of these credentials that we talked about, what I don't have is someone who will sponsor me in terms of putting my name in front of the governor. I don't have a law partner who's on the governor's commission. I don't have friends of law partners who are on the governor's commission. What I have is my experience. Practicing law for over 30 years, I have done a lot of cases. And in those cases, what I have found out is that when the bench treated my clients with compassion, dignity, and respect, my clients really responded well to it. When they treated my clients unfairly, and they treated my clients as if they were lesser than, then my clients did not do so well. And I found my clients being treated more and more like they were not part of the system. And that really was painful to me, and that was painful to them as well. And I wanted to alleviate some of their pain. And that's why I'm running for judge. I really think it is important that the judges treat our community members like they would treat their own family members. That's what I have done as a lawyer. I've represented many people. I've represented multimillionaires. I've represented indigent people who couldn't even afford a stamp to write to me. So I've represented men, women, people on different spectrums. My main representation has been in the juvenile law arena. And so I have had a chance to see what it is like to be born where other people are looking at you as if you have already been lost and they have already given up on you.
30 seconds.
And so because of that, I think it is really important that we have somebody who understands the sort of people who appears in front of the court to actually be on the bench to represent the people of Montgomery County. I have served with distinction as a soldier, as a Bar Association president, as a chair of the MCDC, as a chair of the Montgomery County Criminal Justice Coordinating Commission, and as a lawyer.
That's time, Ms. Pierre. Thank you.
Okay, before we begin our questions, I would like to have two follow-up questions. Mr. Johnson, have you ever gone through the process of being vetted and applying for a judgeship?
6 times. Did you hear my response?
Yes, I did. And based on the process that does exist, I have multiple questions about this from the people view. What do you believe is the basis voters should believe you are qualified?
Well, I feel that my 29 years experiencing practicing law, I have a license in Louisiana, Maryland, and the district. I'm admitted to the Fifth Circuit Court of Appeals, which encompasses Louisiana and Texas. I've written briefs for the Fifth Circuit Court of Appeals. The case was my client versus Federal Express. I've been a solo practitioner. I've not worked for big law firms. I've worked for legal aid in New Orleans, in public housing. I'm also admitted to the Veterans Court of Appeals. There's less than 100 attorneys in the United States that's admitted to the Veterans Court of Appeals. I've handled PTSD, mental health is one of the areas I worked in. I've handled complex cases dealing with employment discrimination and also police misconduct, 42 U.S.C. 1983. I'm also admitted to the Eastern District of Louisiana, where those cases were filed. I feel that my personal experiences, my background growing up in poverty, working my way through, I went to college in Massachusetts, Merrimack College, BA in political science. I feel my life experiences, and I've,
30 seconds.
Okay, the people I surround myself with are from many different cultures.
Yes or no, Mr. Johnson, have you been on the ballot before?
Yes, I have. I was on a ballot once.
30 seconds only for this one. Okay, you've run for a judgeship before?
Yes, ma'am. Last I think 2021.
Okay, thank you. Ms. Pierre, how many times did you apply to become a judge and go through the vetting process, et cetera?
I cannot tell you at the top of my head now, but I know it's been over 9 times. And the reason why I applied so many
Okay,
times-
stop just 1 second then, Ms. Pierre. And how many times have you run for this position before?
This is my 3rd time.
Okay, and so the question that was submitted also is, since you have not gotten through the vetting process, please state the basis voters should use to believe that you are qualified and that you should be a judge.
Well, I am well qualified to be a judge. I would not have wasted everybody's time if I weren't. As I stated before, I've been practicing law over 30 years. I'm a former officer in the Military Police Corps, a former chair of the Montgomery County Criminal Justice Coordinating Commission, a former Bar Association president, the J. Franklin Bourne Bar Association. I have won numerous community service awards and other awards for my services to the community and my law practice, including the Leadership in Law Award, the Bar Leader Award from the Montgomery County Bar Foundation, just numerous awards. But anyway, the reason why I have not been able to be successful at the vetting process is not because of my qualifications. It is because I don't have anybody in the governor's commission. What I mean by that is that one of the reasons why I stopped applying is because I saw that I was hitting my head against the wall. The last time I applied, somebody on the governor's commission was extremely mean and awful to me. And when the person got that position, she then spoke at his investiture, his swearing in ceremony, and talked about how he gave her her first job as a lawyer, and that he and her husband were law partners, and that he and his wife
30
and she
seconds.
and her husband, were regularly together on social occasions. I do not have those sorts of connections. I do not have somebody to move my application forward. And I know there's going to be talk about, oh yes, that's not the way it happens, but we all know that's how it happens. That's how come last time I ran, there were two people who were the former law partner of somebody who's running now.
Okay, we're going to begin the process now of answering questions. And we will start with Judge Dumais on the first question, and that is, what is the most important attribute of a judge, and do you possess that attribute? Judge Dumais.
Thank you, Susan. As I indicated in my opening, I think the most important attribute of a judge is that you're honest, that you have integrity, that you have patience, that you listen, and that you consider both sides of an issue. The Constitution actually indicates that what we want in a judge is that it's someone that has sound legal knowledge and that is sort of considered an excellent, has been admitted to practice and are most distinguished for their integrity, wisdom, and sound legal knowledge. That's the requirements in our Constitution. And that is what I believe I possess. And I believe that the vetting process, which I find to be very important so that we do have the most qualified individuals on the bench, proves that all four of us that have been through that process possess that sound legal knowledge, the integrity, and the wisdom necessary to properly serve on the bench.
Judge Chernowski.
Thank you so much for the question. Obviously, those attributes in the Constitution are clearly very important. I think in addition to that, as Judge Dumais said, the ability to listen and to communicate and to be compassionate. I think one of the things that I bring is my compassion and my empathy for people. After having worked with indigent clients my entire career, I have learned to listen to them. I have learned to be able to communicate for them and to advocate on their behalf. And I think that then being able to sit on the bench and to listen and to be able to provide that amount of compassion to all of the people who come before me, understanding that what they're telling me is very important to them, and that what they're putting forth in front of me is something that they need help in problem solving and in coming up with solutions, and being able to think outside of the box and to come up with different solutions that may in fact help their situation as it goes forward, whether it's with the custody of their children, whether it's with child support and their inability to pay based on their financial situation. Being able to hear all of that in both sides of the story as it's brought before me, I think requires the compassion and ability to communicate after listening effectively to them.
Judge Acosta.
Thank you. I think one of the most important attributes of a judge is patience, and I believe I have that. When people come to court, and frankly, I think folks would be surprised how many people come to court without counsel and who don't have a legal education, they still need an opportunity to be heard. They absolutely come here wanting to win, whatever that means to them, but they want to have their day in court. Win or lose, I want them when they leave the courtroom feeling like they've had a fair opportunity to be heard. I've successfully done that in district court for 4 years. I believe I've continued to do that in circuit court. The patience comes in sometimes with those folks and sometimes with their lawyers, because once again, people are very, very concerned about winning their case. And I need to let them do that in a way that respects the integrity of the court system, respects opposing counsel and the opposing parties, and gives everybody the opportunity to talk. And that does take patience. And I think I've done that. I think people have left feeling like they've had an opportunity to be heard. Thank you.
Ms. Pierre.
As a family law facilitator for nearly 10 years, and as a lawyer who's been practicing law for over 30 years, and someone who has practiced law in Maryland, the District of Columbia, and the state of New York, I think that Judge Acosta is correct. I have heard many people say that the reason why they are so upset over the decision, even though they won, is because they did not feel like they were being treated fairly. They felt like the judge talked down to them and belittled them. And yes, they won, but they did not have the feeling of winning. On the other hand, I have represented people who the judge has taken something away from them, and they felt like the judge was correct in taking that right away from them, because they felt like they were heard, they were understood, and they were treated kindly and humanely. I think it's very important that judges remember that they are public servants. And many times judges don't. I know we're sitting here discussing how nice these people are, but it's the system. When you look at the system in Maryland, you could talk about vetting a lot, but there have been many people who have gone through the system that we are not so proud of. Just recently, over the summer, as a matter of fact, there was this judge who was vetted in Caroline County who got
30
elected by
seconds.
the people. And yet, he was doing all kinds of things to young boys that he should not have been doing. So the vetting process is not a perfect process. And that's why I'm asking the people to keep an open mind.
Judge McGuckian.
Thank you. I'm going to echo a little bit about the same concerns that my colleagues have, and I picked temperament as probably the most important attribute, and there are a lot of subsets of that. I learned after my appointment that during the vetting process, judges, opposing counsel, my clients, my colleagues all said one of the things that I'm very proud of, which is they've never seen me yell. They've never seen me lose my cool or get angry at anyone on the other side, or anyone in court, or witnesses, or anyone. So a subset of temperament, I think, is respect, and that's respect for everyone, respect for the other side, the party on the other side, the lawyer on the other side, the judge, your colleagues, and I bring that with me to the bench. Listening is also a subset of temperament. I spend a lot of time making sure that people are heard. I let them get their last words in. I want them to know that I'm listening to them. I spend a lot of time going over my factual findings in court, and then my legal findings, and I make rulings from the bench. I don't want people to come in and have a full day trial and then come get a written opinion in the mail a couple weeks later. I want to look them in the eye and explain why I believe them or didn't believe them, why I found what I found, and explain my legal decisions so that they understand it and they can feel that they had a fair hearing and
30 seconds.
with a judge that is open-minded and gave them a fair shot. To echo also my colleagues, we get a lot of unrepresented parties in family law cases. And so I spend some time with my unrepresented parties talking about positive aspects of their parenting and reminding them that their children are half them and half their other parent, and that they should respect the other parent and make the child feel good about him or herself. So temperament, respect, listening, I agree with my colleagues on all of those things.
Mr. Johnson. Are you there, Mr. Johnson?
I am. I was just trying to unmute myself. Yeah, thank you. I echo the same things, but I think what's more important, listening to both sides, whether if it's a plaintiff attorneys before you or a defense attorney, listen to the facts. Taking the facts in and absorbing them and applying the law. Treating every person that comes before you with kindness, respect, and be courteous. Also try to understand the different cultures. You have people here from Montgomery County is very diverse. And you have people from different cultures. They have different attitudes. It's traumatic for them. Sometimes it's for them to appear in court for the first time. They've never had that experience in their life. So some cases you have to hold their hand, show them that you care, show them that you understand where they're coming from, showing that respect that they're there and that you're serving them and that you don't have an attitude or have not prejudged them. I think that's important for any judge. I've been before judges in administrative court, federal court, and state court, and judges have different personalities. And you have to learn that some of them are bad, some are good, and you have to help your client to understand that the judge is not your enemy. The judge is here to decide the law. And as a judge, I would also
30 seconds.
bring that to the bench: kindness, compassion, and understanding the law and the facts before me and the people.
The next question is, what was your toughest case to adjudicate? And if you could go back, is there something you might have done differently? And we will begin with Judge McGuckian.
Thank you. Well, to adjudicate, I would say, so sitting on the bench, the first case that I had sitting on the bench was one that sticks out in my mind. It was a case involving a mediation that took place during COVID of custody issues. And it was a husband and wife who lived in the same home, but the wife was a victim of domestic violence. And so they're mediating this case, one upstairs, one downstairs, without the mediator knowing that they're in the same house. There was a protective order that was pending that prevented the husband from being in the same house, but he was there. And they mediated a pretty extensive, without counsel, custody agreement that the husband, the wife finally separated herself from him, but the husband came in a couple months later and was trying to enforce this custody agreement against the wife. And it was a situation where the domestic violence was in front of the children, and it was a very equal custody agreement, something for an individual that had not been particularly involved in the children's lives. So he was attempting to enforce the custody agreement. She was attempting to get out of the custody agreement. So we had a full day merits hearing on that issue. And there was some very difficult testimony, both on the domestic violence side and on the law in terms of overturning and undoing a signed written agreement. So it involved some legal acumen, it involved some listening, and I ultimately decided to overturn that, and it's actually been back. And now after, I think on the eve of trial, they resolved the custody issues and entered into an agreement that made more sense for everyone and was in the best interest of the children.
Okay, Judge Acosta, again, the toughest case you've had to adjudicate, and if you could go back, would you do something different?
I think the toughest case I had to adjudicate was a district court case involving a lady who had decided she wanted to hunt geese with a bow and arrow, a toy bow and arrow, in a park that had a school on one side, apartments on the other, children and parents playing in the playground areas. And folks saw this, were rightly concerned, called the police. The police, you could tell from the 911 calls, were confused as to who should respond. It was in Gaithersburg City. Did Natural Resources come? Did Montgomery County come? Did Gaithersburg City come? And as a matter of fact, they all came. So they all show up, the lady's there. And the lady, and this is where I think that the greatest difficulty, though there were other ones, was the fact that unfortunately she had a very, very difficult speech impediment, such that whenever she started talking, she had a very, 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 very hard stutter that would stop her from finishing any sentence. So it took a long time for them to interview her and figure out what was going on and issue her a citation. The state's attorney's office believed they had a locked case because the lady admitted on body-worn camera at the scene in daylight that yes, she was shooting arrows at these geese. The interesting thing was, and so number one, we had a trial
30
involving
seconds.
a sign language interpreter that really wasn't necessary. It was just somebody who needed to be able to read what she typed. So she would type it. This is a trial that took probably about 4 hours for $100 fine. I found her not guilty because she had confessed, but they didn't have any proof to support the confession. In the state of Maryland, you have to have some evidence to support the confession. So she got her day, she won her case, but it was very difficult because she felt that we weren't listening.
That's time, Judge. Thank you.
Thank you. And obviously we were because she won. Thank you.
Judge Chernowski.
Thank you so much. I think that the most difficult case I've had to adjudicate so far is a custody case in front of me where it was clear after both sides presented their case that both parents very, very much loved their children and very much thought that what they were articulating was in the best interest of the child. And there was some expert testimony about how even if the parents aren't doing something intentional to alienate the child from the other parent, that somehow their attitudes or just their demeanors can relay information to the child, or that the child can just feel conflicted between both parents. So in this situation, both parents would go to the child's practice, for example, and would both be there. And the child, there was actually 3 children. So the children wouldn't really know what parent to go to when they were at this practice. So there was a custody evaluation done, and the custody evaluator found that the children were feeling alienated when both parents, trying to do what they thought was in the best interest and to be involved in their child's lives by going to these practices, was actually creating conflict for the children, because when they got to the soccer field and both parents were there, they couldn't decide who to hug first or who to high five first or who to go to figure out how they did on the save as the goalie. And so it was really difficult to be able to decide how to arrange a custody agreement that would allow the parents to participate as much as they
30
wanted
seconds.
to. Thank you. Without creating that acrimonious or that conflictual feeling for these poor children who are trying to love each parent. And I think what I learned and what I would do better next time is to get a best interest attorney involved in the case, because the best interest attorney then will talk to the children and get information from the children to be able to bring forth to the court. Thank you.
Judge Dumais.
Thank you, Susan. Over 60% of the cases that are filed in the Circuit Court for Montgomery County are family law cases. And that's a huge number, and we all spend a great deal of time on it. I think the most difficult cases that I handled as an attorney and that I have adjudicated are ones where in custody cases, one parent relocates. Because the bottom line is somebody is losing. One parent is not going to be able to see the child as often as they do, assuming they're living in the same jurisdiction. And I struggled mightily with the case that I have adjudicated, and I struggled when I served as a best interest attorney for children, because again, it's the children that sort of get harmed or lose the opportunity to spend a great deal of time with the parent, either that they're moving with or the one that is going to be staying here if the children are gone. Those are the toughest. And what is most striking about those cases and makes them most difficult is so many times both parents are excellent parents. It is not a question of one's bad, one's good. And the parent that's moving may have an excellent reason for moving, whether it is a new job opportunity. And one where I served as a best interest attorney, and the best interest attorney usually makes a recommendation at the end of a case. And in that was a really hard case. The mother had really done so much for the children and really struggled through
30 seconds.
Thank you. Infidelity. but, managed to get to the point where they had a week-to-week arrangement. The children loved both parents, loved the new parent, both parents subsequently remarried. And I didn't know what the best thing to do was. And I thought the children should move with the mother, whose new husband was in the military. The judge disagreed and the children stayed here. And they stayed here because that judge said, I know mom will make this work because mom always does. Those are awful cases. Important
That's tough,
cases,
Judge. Thank you.
but they're really hard. Thank you.
Okay, so Ms. Pierre, you haven't adjudicated a case, but as a lawyer, what was a tough case that you dealt with? And as you look back now, you probably should have done something different for your client.
I think that there's so many, it's so hard to choose, but I think one of the most recent ones that I have has been really heartbreaking for me. I represent a 4-year-old whose visitations were suspended with her mother because her mother would go into the visitation room before the visits and clean up the visitation room. We're in the age of COVID. The mother felt like the visits at the department visitation room meant that other families visited in there, and she wanted the room as clean as possible for her child. She wanted the room as safe as possible for her child, so she bought in those plastic electrical outlet plugs to put in there. For whatever reason, the social worker did not think that was a good idea. And so the social worker went to court and asked the judge to suspend her visits, not even limit her visits, just suspend, well, not even limit her visits more than they were limited now, but to actually suspend her visits. And the judge actually suspended the visits. So we have a 4-year-old who goes from living with her mother. And I agreed with the Department of Health and Human Services that this child needed to be removed from the mother, but I also advocated for her in terms of having the child see the mother twice a week, which is a lot if you do these sorts of cases. But then to go from visiting the mother twice a week in a supervised environment to not visiting her at all. It reminded me about the cases that I have where the children, when they don't see their parents, have asked me, has my parent died? This 4-year-old is not verbal, so she cannot say that. So I could just imagine the feelings that she is feeling right now and how she's going to be dealing with that trauma as she goes on in life.
Mr. Johnson, same question, a case that you would do something different on your most difficult case?
Well, I had a case, I got a call the day before I was flying out to New Orleans to participate in an administrative law hearing for a client. And the person here in Montgomery County was facing a default judgment of $360,000. She was like 80 years old. So I took the case, not knowing at the time that there were like maybe 60 other people facing the same default judgment. So I took the case, filed the papers when I got back, and it was sent to Judge Mason, I believe, and we had a 3-day trial. I had clients to show up to participate in the trial, and I had clients that did not show up. And what you had clients, and I met with all of them. They were from, I think, maybe 16 different countries. So to convince these people to show up to court was very difficult. So anyway, I was looking at the judgment, and this was pro bono now. I was looking at the judgment. It was a 3-day trial. I won it. What I would have done differently, I think I would probably have referred the case out to someone. But my compassion for others, I took the case and succeeded with the case. And, you know, diligent representation on both party in New Orleans, and
30 seconds.
And a party here. So I don't think I would have done anything different. The only thing I would have done differently was referred it out to someone. But I was looking at what the default judgment that this elderly lady was facing.
Okay, this next question, I'm only going to give you 90 seconds in the interest of time, so we get more questions in. in circuit court, it's important that you deal with expert witnesses in trials. How often did you, as a trial attorney, cross-examine expert witnesses in any kind of a case before the circuit court? And please just say something about those examinations. 90 seconds, and we will begin with Mr. Johnson.
Okay, my only expert witness experience came in administrative court. I had, it was mental health. My expert witness dealt with post-traumatic stress disorder. The expert witness on the other side for the U.S. Post Office also was a person with PTSD expertise. And so this trial lasted, it was administrative law, administrative trial, but it lasted 7 days. So I've had, I mean, you can extrapolate, you can take that expert witness, whether it's in state court, federal court, or even in administrative proceedings, they're all the same. So, you know, there's there's a term that Dobert has, you know, you look at whether the person that had the education experience and whether they've been doing, how long they've been doing it.
30 seconds.
And basically, when you have an expert, you have to qualify that expert. Thank you.
Just one quick follow-up. How many expert witnesses do you think you've examined?
Two.
Two, okay. Next, we're going to go to Judge McGuckian.
Thank you. I've directed and cross-examined scores and scores of expert witnesses. I'd probably say 50, 75, maybe more. It's something I actually very much enjoy, but I've had a pretty broad practice. So the experts I've dealt with are doctors, lawyers, real estate appraisers, valuation experts, a lot of those, government contractors, engineers, accountants, international law experts in family cases. So Maryland actually just switched changed the tests that they use for expert testimony. Maryland used to be in the minority. We had it's called a Fry-Reed standard. And in 2019, the Court of Appeals changed that. And now we follow the Daubert standard. It was the Roshkin case. So as a judge, I've already held a Roshkin hearing, so a Daubert hearing, and to qualify an expert. So I very much enjoy the practice of cross-examining experts, even more than directing experts, but
30 seconds.
It's something I've done well and often. I think one of my favorites was I had an annulment case in the circuit court for Montgomery County that I won, and I had a Mexican law expert come in to talk about the qualifications for individuals to be legally married in Mexico, and I successfully challenged a Cancun marriage that was not properly witnessed in Mexico using an expert from Mexico. Thanks.
Ms. Pierre.
Yes, I have examined and cross-examined numerous expert witnesses. In juvenile law, there's always an expert witness there. The social worker is always considered an expert witness. I have cross-examined many expert witnesses in that arena. I have also had my own expert witnesses in cases. I have cross-examined expert witnesses who are psychologists, psychiatrists, therapists, substance use disorder experts, all sorts. Also in my criminal law cases, I have cross-examined police officers. In my protection, well, I had a protection, yes, I had a domestic violence case where where my witnesses were police officers.
30 seconds.
And so I have also qualified police officers as experts. So I have lots of experience dealing with expert witnesses.
Quick follow-up, numerous, what does that mean? Give me an estimate. Are you talking 20, 40, 10, 12, what?
More than 40, more than 60, more than 75, I would say, because I have regular cases involving expert witnesses.
Okay,
We're
just,
talking about,
the question is though, are you including police officers as expert witnesses? I wouldn't, I do not count police officers as expert witnesses. So so if you exclude the police officers, how many do you think you've talked to?
definitely more than 70, I would say, because like I said before, I do juvenile law and we always have an expert in there.
Okay, thank you. That's all, thank you. Next, let's go to Judge Acosta.
Thank you. I don't know that I've ever used experts as a defense attorney. Generally, the experience I've had with experts has been as a prosecutor. And I'll hit the number now. I would tell you, usually my go-to expert in my time as prosecutor was the medical examiner, if I have to think about it. And frankly, there's only one, and the government brings that person. But I've also used chemists, had gang experts, I've had firearms and tool mark examiners. This is, of course, in criminal cases. To prepare for those kind of cases, for direct examinations, I'm generally the person bringing the expert. I try to meet the expert in their office or laboratory. I try to review their paperwork, I review their opinion, and then I, in essence, question them in their office to make sure I understand what they're going to talk about, to make sure that the questions I ask are appropriate to the facts that we have. When I find that an opposing party is going to bring an expert, I have the right to call that
30
expert.
seconds.
And I do. I will generally call them. I'll try to have my expert on the line as well. I do remember and recall cross-examining opposing counsel's mental health experts. And it always seemed to me, and this is as to the competency of the defendant, that while, of course, that expert's being called because they're diametrically opposed to my expert witness, they base their opinion on a substantially smaller data set than mine. And I would try to point that out to the jury. Thank you.
Judge Chernosky.
Thank you so much. I have cross-examined and called witnesses in all types of the criminal cases that I have handled. In murders, there are pathologists, there are medical examiners, there are DNA experts, there are toxicologists. In rape cases, there are DNA experts. I think we are privileged in Maryland to have a state public defender system where if I, as a defense attorney, wanted an expert, I could get funds from our office in Baltimore to be able to hire experts. And I think where I found this most helpful was in our shaken baby child abuse cases. So a child abuse case that resulted in the death of a child where the allegation was a shaking. There are medical personnel who can come in and look at all of the medical records and determine whether or not they can be an expert for you. I think, at least in my experience in front of juries,
30 seconds.
Thank you. So important to have very specific cross-examination points and to have experts of your own, because the jurors really find expert testimony important. And so it was a critical part of our defense. Thank you.
Judge Dumais.
Thank you. So the distinction between an expert witness and a fact witness, as you may have discerned from some of the answers, is that an expert witness can offer an opinion, and in offering the opinion can also usually use hearsay evidence, which is what somebody outside of the courtroom said that a fact witness is not able to do other than in certain very special circumstances. So I have probably, as Judge McGuckian has indicated, minimum of 60 to 80 case sort of expert witnesses over the course of my career, probably many more than that in fairness. And the kinds of expert witnesses that I would cross-examine or call as my own witness and direct examine would be valuations for business valuations in family law cases or divorce cases, certainly different psychological experts for custody cases. I think the one that I remember the most was somewhat early in my career. It was a custody case, and opposing counsel had called an individual whose name was Dr. Richard Gardner.
30 seconds.
Actually wrote books about parental alienation and called sexual abuse and allegations of sexual abuse witchcraft. Dr. Gardner was eventually discredited by the entire social science community. But I was very pleased when the report came out on this case that basically, based on my cross-examination, the magistrate found that she took nothing that Dr. Richard Gardner said as credible and discounted his entire testimony. So it's a very important part of the process when you're bringing an expert in to make sure they're qualified and in cross-examining them to be able to indicate why they're wrong and what their background stands for not having enough information. Thank you.
Okay, and I'm only going to give you 90 seconds for this one also. Obviously, as a judge, you have to stay on top of the laws that are passed each session. And I'd like each of you to discuss any bill that you think passes legislation that will impact your role as a jurist and why. And we'll begin with Judge Chernosky.
Thank you so much. I think as a prior public defender, I have a little bit of an interest in some of the criminal laws that have passed. And part of what I've seen in the legislature lately is a trend towards making some improvements in parole and parole eligibility. 2021, I think, is when they made life without parole for juveniles no longer effective. And Judge Dumais, I know, was integral in that. And in the new override that happened where they overrode Governor Hogan's veto of him having the last say for parole eligibility. I think that the legislator is seeing that there are changes that need to happen in the criminal justice system to address some of the incarceration rates that exist in Maryland. So it's very important that the governor is not the ultimate say in parole eligibility for those who are in for life. And that's what I think is important in going forward.
Next, Judge Acosta, again, a bill that's recently passed in the legislative session, and how would it affect your role?
Thank you, Susan. Susan, like the other judges, when I first came on board, I was a family law lawyer. A couple of weeks ago, because of the movement in the courthouse, I became a juvenile judge lawyer. So obviously my focus began to look at what the legislature's passing. The Senate Bill 53 proposed, and they passed, and it was a veto override, the Child Interrogation Protection Act. And this is very interesting because now in Maryland, law enforcement officers prohibited from conducting custodial interrogation of a child until that child is consulted with an attorney. And law enforcement officers made an effort which is calculated to give notice, actual notice, to a parent or guardian custodian child be interrogated. That didn't used to be the case. The bill establishes a rebuttable presumption that the statements made by a child during a custodial interrogation is inadmissible in specified proceedings against the child if the officer willfully fails to comply with the bill's requirements.
30 seconds.
While, of course, judges always had to look at custodial interrogations through the Miranda lens, now in juvenile court, there are additional steps that prosecutors have to take before I'm going to consider a child's statements as evidence. So I think that's a very big case. Or a very big statute. Thank you.
Ms. Pierre.
In terms of bills that have been passed, I think the general legislature did a great job this session. But I really think that we need to go back to what we're here for, which is for the bench. I have found in my experience that the person who is making the decision really decides what the bill is. The bill could say whatever it is, but like I said, the person making the decision decides what the bill is. For instance, you could go back to Plessy versus Ferguson and Brown versus Board of Education. In those cases, the 14th Amendment of the United States Constitution was what was looked at and interpreted. Yet these two Supreme Courts interpreted that 14th Amendment very differently. We could see this today as what is happening. So I don't so much look at particular bills. I look at the people who are going to interpret those bills.
Okay, 30-second follow-up. If you were a judge, what legislation that was passed in this last session would have an effect on you and how if you were a judge? That was the question.
Well, if I were a judge, I would look to see what is happening now that makes Maryland the state that incarcerates a higher percentage of its young Black males than any other state. We could pass any laws that we want, but if we have judges on the courts who are going to interpret those laws to incarcerate our young Black males and in such high proportion, it doesn't make a difference what the law is in that sense. We have to look at the bench.
That's time. Thank you.
Judge Dumais.
Thank you, Susan. So I think one of the bills that it's actually a criminal law, but the impact that it is going to have on domestic violence cases is amazing and huge. So the bill that I'm speaking about is House Bill 148, and it alters the definition of stalking to include conduct that currently isn't included under stalking, specifically that stalking can be done by electronic means or through the use of a device that can pinpoint to track the location of another without the person's knowledge or consent. I certainly in my practice handled domestic violence cases. I've seen them here, and it's always been very frustrating that stalking, the definition is a malicious course of conduct, but it's always been something that's been in person. Someone stalking, following you around or stalking you at your place of work. This allows what we all know is really stalking,
30
which
seconds.
is the communication through electronic means. I think we're going to find that it has a great impact in the domestic violence field, as well as, certainly in the criminal field. So I think that's something that was most important in the family/domestic violence field in this last legislative session.
Thank you. Mr. Johnson.
Yes, there's many I can think of, but one comes to mind is the recent hate crime bill. I think it's a House Bill number 5, which was enacted in came into law 2021. And, it deals with symbols, placing SWAT stickers on a person's lawn, hate speech. I think it affects us all, and it's a criminal penalty. And the place in our society today, we've gotten laxed, and some things you're supposed to accept things. And I live in a community where it's predominantly Jewish, and those things not only offend my Jewish brothers and sisters, but it offends myself. So I think that it's a bill that is needed into today's society, and it shows that
30 seconds.
There's sensitivity, but it also means that the judge have to apply it with discretion.
And finally, Judge McGuckian.
Well, thank you. My colleagues on the bench mentioned some new laws that are very important to the issues that come in front of us. But to add to that, there were 2 really good laws that were passed related to untraceable firearms. And these are sometimes called ghost guns. But one of the laws prohibits the purchasing, receiving, selling, transferring, pretty much everything to do with unfinished guns. And these are guns without serial numbers. It imposes some steep penalties on the transfer, possession, purchase, and receipt. There's also a new law that even precludes the possession of an unregistered firearm. And the way I see this unfolding in the cases that come before me mostly have been through search warrants so far, but I've received and made decisions on many search warrants related to crimes committed using these unlicensed, untraceable ghost guns. These are guns that you can, that kind of look like a Glock 9mm, but they come in 2 pieces, no
30 seconds.
registration. People can purchase these kits through the internet. They can go down to Virginia gun shows and people pay hundreds of dollars more for a ghost gun than they would for a fully assembled Glock. So it says a lot that the Maryland legislature has given the tools that are necessary to prevent these weapons from infiltrating our communities even more. So I think it's very important.
Thank you. And now we're going to go to 2-minute closing statements. We're going to go in alphabetical order. Reverse alphabetical order. So when it's your turn, just start. So obviously we are going to begin with Ms. Pierre.
Good morning again, District 18, and I thank you very much for listening. My name is Maryland Pierre, and I am a candidate for Montgomery County Circuit Court Judge. I am running for judge because I think that judges should treat people with compassion, dignity, and respect. I represent a lot of poor and disenfranchised people, and they have not been. I have the qualifications to be a judge. I've been practicing law for over 30 years, and I have done really well in that. Most of my practice is with family law, so that's why if you look at case search, most of my practice has been in juvenile law, which is why if you look at case search, you're not going to find many of them because they're confidential. I have served as a soldier, a lawyer, a president of a bar association, a chair of the Montgomery County Criminal Justice Coordinating Commission. I have served in all those positions with honors and distinction. I ask that you allow me to serve as a judge with honor and distinction as well. Please vote for me, Maryland Pierre, for Montgomery County Circuit Court Judge. Vote Maryland for Maryland. Thank you.
Thank you. I want to thank the Breakfast Club and for everyone that participated today. In closing, I'd just like the voters to consider who you would want deciding your important cases, or an important case for your business or your family member or your friend or your neighbor. Who do you want on the bench when the issue is important to you? I would want a judge who knows what he or she is doing, someone who has been vetted, someone who has experience, and someone with good judgment. And one of the challengers has argued that the appointed judges are an in group, and then if you're not in the in group, you're excluded and you won't get nominated no matter what. That's just not the case. It's not how the process works. Everyone has a fair shot. Everyone goes through the vetting process and is treated equally. Only successfully vetted candidates are nominated to be judges, which means that only qualified judges are appointed. As Judge Tarnowski talked about, there are 13 local, state, and diversity bar associations that vet the applicants. They're again vetted by the nominating commission, which includes non-lawyers. Every aspect of our lives were investigated. Judges are called, opposing counsel are called, clients, colleagues, no stone goes unturned. The vetting process ensures that those of us who make it through are qualified to serve in this extremely important job for our community. If challengers who are not successful in the vetting process are elected, they sit for 15 years, and there's no vetting them after the election. So again, please think about who you want deciding your criminal case, your real estate dispute, your custody case when you go to vote. Vetting truly matters, and I strongly urge you to support the sitting judges. Thank you. I'm sorry, did you say 30 seconds? I wrapped it up, so I'll move it on. Thanks.
All right, I also would like to obviously thank the, I'm sorry, it's Mr. Johnson's turn.
Yes, it's Mr. Johnson's turn.
I apologize.
That's okay, Mr. Johnson.
Yes, ma'am. Yes. First of all, to the voters out there, to the audience out there, thanks for being here this morning. I want you to remember, your vote counts. You shouldn't let 13 people decide for you that they put who they feel should become a judge. The vetting process, I've gone through it. Do I think it's fair? No. Do I think it's impartial? No. I've gone through all of the bar committees. To find more information about myself, go to tpjohnsonforjustice.com. Another thing I want you to keep in mind, these judges sit for 15 years once they pass the voters. You don't get another opportunity to select them. This is it for 15 years. One thing you also should keep in mind, I heard that you have a diverse court. Well, how can you have a diverse court when you have 24 circuit court judges and you have no African-American males and you haven't had one in 6 years, and the highest percentage of people who are placed in incarceration are Black males? Let me give you these figures. Montgomery County has one of the highest pretrial incarceration rates in the nation. A person spends 6 months in jail before they get to see a judge. On average,
30 seconds.
this comes from statistics of the circuit court. Is this what justice should look like? No. That's why I'm running for judge, and that's why I'm asking for your vote. Thank you.
I apologize for jumping in too soon. I am asking for your vote for myself, Judge Dumais, as well as Judge Acosta, Judge Chernosky, and Judge McGuckian. And I just want to sort of repeat. So what the Constitution requires is that you be a citizen of Maryland and qualified to vote, that you reside in Maryland for not less than 5 years and not less than 6 months in the jurisdiction that you want to be a judge, and that you're at least 30 years of age at the time of your appointment or your election. So if I graduate from law school at age 28, at age 30, with 2 years of practice, I'm eligible to be on the ballot with no vetting whatsoever. So the Constitution doesn't give very much guidance to the governor who makes these appointments. And in 1970, it was Governor Marvin Mandel who issued an executive order that created the first Judicial Nominating Commission. And every governor since that time has used it. And I disagree with the challengers. It is a fair process, and it is impartial. And it is not just 13 people. It is hundreds of people that we go before by the time it even gets to the nominating commission. And then by the time it gets to the governor, who does his or her own investigation, which includes, again, talking to the collaterals, talking to people that know us personally as well as professionally, talking to opposing counsel, which I think is important. Sort of, what do they say about you? Have you been,
30 seconds.
A proper opponent? So I believe that is it perfect? Nobody's going to suggest that this particular process is perfect. However, it does provide the voters with individuals sitting on the bench who have been vetted, who've been approved, and have been determined to be qualified. And I respectfully ask that you elect the sitting judges. Thank you.
Thank you all for being here and for listening to all of us to gather information to make an informed decision when you go to the polls. I think one of the things that I'm hoping that you take away from this is that the 4 seated judges, they are diverse in terms of their background. And for a career public defender, that is very important, because I too have sat with many a client who have been in front of judges and have not been treated fairly. And I think part of what was missing from the bench that has been improved in the last probably 7 or 8 years is the diversity and the quality of people who have been appointed to the bench. So in our diversity, I think that we bring to the bench different perspectives, and we can call on each other for individual questions about other people's area of expertise. It is a long process, or it can be a long process. I have tried to be appointed since 2013. So I too have gone through the vetting process numerous times. It is difficult, it is arduous, it is humbling, to be honest. And I have been honored to represent all of the people in my career. They have entrusted me with their freedom, and some of them with their lives. I was honored and humbled when I got onto the short list that people determined that I was
30
qualified.
seconds.
Thank you so much. They had spoken to other people who I have worked against and come before, and all of them felt that I was someone who would be a good person on the bench. And I would be honored if you would elect the 4 of us, the sitting judges, to continue as judges in Montgomery County Circuit Court. I think that we will make you proud.
Judge Acosta.
Thank you. Folks, thank you all for your time today. I appreciate the time and the effort that you've invested to become acquainted with us this morning. been fortunate in my career to work in various locales throughout Maryland, the United States, and the world. My career has given me an opportunity to work and learn globally and to bring that experience back locally. Even though I've been exposed to various systems, some more like ours and some less, everywhere I went, I met people who wanted a system that works. And I'm talking everywhere: Mexico, Latin America, Kosovo, Malaysia, Borneo. I've been very, very fortunate to have traveled on behalf of the government, the State Department, the United Nations, to talk to folks about how to improve the criminal justice system. It was a desire they wanted, which is the same desire our citizens want. Everybody wants a system that they can believe in, that reliably delivers fairness, justice, and an opportunity to address their grievances. Complex problems deserve thoughtful responses and good judgment. Good judgment comes from experience. I firmly believe that the 4 sitting judges, Judge Chernosky, Judge Dumais, Judge McGuckian, and myself, deliver exactly that. Please vote for us. Thank you.
I would like to thank our 6 guests today. This has been one of the most interesting, thoughtful forums that I've witnessed in a long time. And I know it's tough being on the ballot, and it's a hard slog, and I appreciate your time and energy this early in the morning. Thank you very much. The tape of this meeting will be sent out today or tomorrow. It will get there, get to all of you. I just want to remind everybody that on June 13th, we're going to have the Attorney General for the state of Maryland as our guests, Congressman Anthony Brown and former Judge Kitty Curran O'Malley. So thank you all very much. Enjoy the sunny day. And I'm hoping that soon, Maryland, that we will be back at the Tasty Diner. So thank you all very much again. Have a good day, everyone, and see you next month. Bye.
Thank you.
Thank you.
Thank you.
Thank you, everyone. Have a great day. See you next month.
Bye.